I was on the Bigger Pockets forum and I noticed a post from an investor struggling to figure out a way to make sure how to get their rental property out of their personal name and into an LLC. What's worse, they were about to make a move that could not only get them in trouble with their lender, but could potentially cost them tens of thousands of dollars in taxes. I'm Jeff Hampton, asset protection attorney, best-selling author of The Investor's Blueprint, Asset Protection Made Simple, and the founder of STR Law Guys. In this video, we're breaking down this very important Bigger Pockets post, and we're going to show you exactly how you can protect your rental real estate while also avoiding problems with your lender, and you certainly want to avoid thousands of dollars in unexpected taxes. Stick around, because following the wrong advice here could cost you everything if greedy lawyers come after you in a lawsuit. Let's start by seeing exactly what this post said. Hi, I have 4 single-family home investment properties, all bought in my name. I've owned them for a few years now. Can I move them into LLCs now without refinancing? I'm hearing mixed opinions from people I know. Mixed opinions? This could get you into trouble. Let's break down the 4 main points you need to know before you ever take action on somebody's mixed opinion. Number 1, because he had single-family homes, we can assume here that he likely had a conventional mortgage on each of his properties. Moving a property from your personal name into an LLC with a conventional mortgage could technically trigger a due on sale clause violation in your conventional mortgage. What is the due on sale clause? Well, every conventional mortgage has within its contract language, a provision that if you try to move the property title from your name to anyone else, including an LLC that you control, it could trigger what's known as the due on sale clause, which means because you did not get the approval of your lender, the lender could technically either call your note due in full or raise your interest rate level to market rate. But always check your paperwork, because if you happen to have a conventional loan that is a Fannie, Freddie, or FHA loan, there are specific provisions within the governmental guidelines that say that the government will not call your note due if you move it into an LLC. However, if you're using a second home loan or an investment loan, there is technically a risk here that your lender could call your note due, but that usually only happens if you're talking about having a low interest rate, let's say less than 4.5%. If your rate's super low, you'll want to be careful here, and you can definitely use the solution we're going to provide here in just a moment. Number 2, moving your property from your name into an LLC could trigger a state-level real estate transfer tax. You have to watch out here, because over 75% of states throughout the country assess some level of real estate transfer tax from transferring property from one person's name to the next, including if it's an LLC. But wait, how does this make sense? You're only transferring title of property from your name into an LLC that you still control. Why would you have to pay the tax? Well, legally, the moment you transfer title from your personal name into an LLC, you no longer own the asset, but you still control it. Now, in theory, this is actually a really good thing because it provides you the fundamental basis of asset protection. The downside, many states, I would say most states, including Florida, California, Tennessee, they charge you a real estate transfer tax. It can range from as low as 0.1% of the value of the property all the way up to 3% of the value of the property simply by changing title from your name into an LLC. If you don't know the legal strategies to avoid this consequence, you could end up with a shocking tax bill that could effectively ruin your investment. Now, before we get to the solution, what about number 3, refinancing? What if you move the property into an LLC and then later you want to refinance your conventional loan? Unfortunately, your conventional lender will not allow you to refinance your mortgage in an LLC. So, in order to complete the refinancing of your mortgage, the lender will force you to move title out of the LLC back into your personal name. But when you do that, you'll be double taxed. Think about it. First, you're taxed by moving the property title out of the LLC. Then after you complete the refinancing of the loan, you'll want to move it back into the LLC for asset protection. You're effectively taxed twice. I don't know about you, but this could be devastating from a tax perspective. Just when you think you're going to lower your carry costs on your loan, you're going to end up being double taxed by the state. So what is the solution here that this Bigger Pockets investor needs to know? It is simply a land trust. A land trust is a simple grantor trust that allows you to avoid all of these consequences. So how does this work? A land trust is merely a simple grantor trust that you, as the grantor, transfer title into this land trust. And you maintain total control over the entire trust, and you can use a mechanism known as the assignment of beneficial interest. You, as the beneficiary, can assign your value in that trust, which is all the equity in your property, into an LLC in the state where your property is located. By doing this, all of the value of the property is now in an LLC, so any greedy lawyer would have to sue that LLC, but both the title and the debt remain in the land trust, effectively helping you, number one, avoid the real estate transfer tax in most states, and it also gets your lender off your back. A federal law that was passed way back in 1982, known as the Garn-State-Germain Act, allows you to use this land trust as a way to both, number one, avoid any problems with your lender, number two, avoid that real estate transfer tax, and to allow you to start establishing some level of asset protection for your rental real estate. This now brings me to number 4, asset protection. Now that you've moved the value of your property from the land trust into that LLC, do you actually have asset protection? Unfortunately, probably not. Why? Because only a handful of states throughout the country actually have laws that are written that provide you the essential things you need in terms of asset protection to ensure that your rental real estate is truly protected from greedy lawyers. And the main thing that you need to make sure you have for your properties is you need to have privacy so that greedy lawyers can't look in and do asset searches on you. Number 2, you want to make sure you have what's called charging order protection, which means now attorneys cannot force the sale of your property in a lawsuit. And then thirdly, you would love to have single member LLC protection. Now, how do you make sure you can protect your rental real estate if those properties are located in a state with weak laws? Check out our best-selling book, The Investor's Blueprint, Asset Protection Made Simple. Or check out this next video where I break down the specific strategy that no matter where your property is located, you can make sure your assets are protected from greedy lawyers if you get sued. See you over there.